So this is an article from the NRA's website. It was posted January 25th of 2011. It's written by Dave Hardy. It's titled "No Surrender: The Straight Skinny on the Firearm Owners Protection Act, the law that saved gun rights." Nearly a quarter century ago, the Firearms Owners Protection Act was signed into law. Looking back, it seems like an impossible victory. By Dave Hardy. When the struggle started in 1979, Jimmy Carter was in the White House. Senator Ted Kennedy of Massachusetts and Representative Peter Rodeo of New Jersey controlled the two judiciary committees that would have to approve the bill. And when the long haul was ending some 7 years later, the measure had passed through the Senate, but Rodino still chaired the House Judiciary Committee and was proclaiming the bill dead on arrival. At the outset, NRA was a fraction of its current size, rejoicing in having grown from 600 members to a full 1 million. The NRA Institute for Legislative Action was barely 4 years old. The internet was still far in the future, and anti-gunners had a solid lock on mass media, where gun owners were depicted as demonic and the NRA the Prince of Darkness. All images perpetuated by what is today known as the Brady Campaign, the American Bar Association, and the U.S. Conference of Mayors. The fight seemed impossible, yet we won. Firearms Owners Protection Act, as it became known, didn't just change the restrictive Gun Control Act of 1968. It overruled no fewer than 6 anti-gun Supreme Court decisions and about 1/3 of the hundreds of lower court rulings interpreting the Gun Control Act. To understand how vital this victory was, we have to take a trip into the past. Many gun owners and activists are too young to appreciate what we today call the Gun Control Act of 1968 is largely not what was passed in 1968. What exists today can be abused, but what was passed in 1968 guaranteed abuse and virtually ensured defeat to any honest firearms owner who accidentally ran afoul of its terms. The statute combined dangerously with the needs of a small but growing government agency. What is today the Bureau of Alcohol, Tobacco, Firearms, and Explosives began as a small branch of the IRS, mostly directed at shutting down moonshiners in the rural South. In 1968, it had barely 200 agents assigned to gun cases. The rising cost of sugar ruined the moonshine industry, and survival of the agency required its bureaucratic leadership to shift into firearms enforcement, a fact that suited the Carter administration's anti-gun goals nicely. Agents were forced to move to urban areas and pressured to generate firearms confiscations and prosecutions at any cost. Many agents resigned or took disability retirement. Those who remained had to quickly produce cases and confiscations. But they had been trained to bust moonshiners in the hills, not to make undercover buys in the city, which could be quite dangerous. Many turned to making cases against targets that were easier and safer to deal with, namely gun collectors and dealers. The original Gun Control Act was an invitation, actually dozens of invitations for abuse. Among its worst features, convictions could be obtained even though the gun owner thought he was complying with the law and erred by accident. There was no requirement to prove criminal intent. Many provisions of the law were so ambiguous that it was hard to tell what was forbidden and what was allowed. But since honest intent was no defense, a wrong turn meant a felony conviction. One of the greatest ambiguities was the definition of who had to get a federal firearms license or be guilty of dealing in guns without a license. The law simply said that anyone who is engaged in the business of dealing had to have a license. Some courts bought the argument that this could apply to selling 4 or 6 guns over a year or so of time. Mass confiscations were simple. The Gun Control Act allowed not only the seizure of guns allegedly used in a violation, but also of guns intended to be used in one. If a gun collector or dealer could be charged with one violation, it could be argued that he intended to use his entire collection or inventory in violation of the law. Once guns were seized, there were no time limits for beginning forfeiture proceedings. The agency could simply seize an entire inventory, thus ruining the dealer, and wait months or years without giving him a court date. The courts had held that even if a gun owner was found not guilty of criminal charges, the prosecution could still forfeit his guns or revoke his dealer's license. Dealers' records and inventories could be searched and reviewed at any time for no reason at all and as often as agents wanted. The agency took full advantage of these features. Undercover agents would attend gun shows, pick their targets, buy a couple of firearms from each, repeat the process at another gun show or two, and they had the magic 4 or 6 sales that would prove the collectors were engaged in the business of dealing. At the next show, the targets would be arrested on felony charges and marched out in handcuffs. Then their entire collections would be confiscated. Dealers were targeted in other ways. One imaginative case was brought against a dealer who sold a few personally owned firearms, which had never been in his business inventory, without filling out federal transfer forms. The prosecutor argued that the Gun Control Act simply said a dealer must record all sales, and that included guns not in his inventory. The dealer's attorney managed to obtain a letter from the head of the BATFE to a U.S. senator, assuring the senator that the agency had never required a dealer to record sales of personal, non-inventory guns. The prosecutor got the director to write another letter saying he was wrong, and the agency did require such records. Since criminal intent was not a requirement, the dealer became a convicted felon for acts that even the BATFE director thought were legal. The agency records of firearms seized reveals its focus on collectors. 60% of seizures were rifles and shotguns. One seizure included 48 Marlin rifles from the 19th century. Others involved Parker shotguns and Winchester Model 21s, hardly tools of street criminals. In one case, the agency sat on the seized guns for 2 years without taking action. When the owner sued for their return, he was promptly indicted. The courts had held that even if the gun owner was found not guilty of criminal charges, the prosecution could still forfeit his guns or revoke his dealer's license. Similar tactics were used against dealers. In one case, the dealer's records were audited in detail, and he was then indicted on 115 felony charges. Each transfer form that listed the buyer's city, but not his county, was made into a separate charge. Dealers' inventories were seized, ensuring that they would be ruined even if acquitted. To create maximum fear, dealers and collectors were arrested 6 or 8 at a time, followed by waves of publicity. Something had to be done, and in early 1979, the newly created NRA-ILA obtained the first congressional hearing on abuses of the Gun Control Act, chaired by Senator Dennis DeConcini of Arizona. A Democrat from Arizona. The lead witness was David Moorhead of New Hampshire, a disabled veteran who the Veterans Administration had set up in the firearms retail business, but who was indicted on highly technical charges. A federal judge threw the charges out and chewed out the prosecutor, but the agency kept Moorhead's inventory anyway. He was followed by other collectors and dealers who had been similarly treated. Senator DeConcini said, "Frankly, I was shocked by yesterday's testimony. The problem appears much greater in scope and more acute in intensity than I had imagined. It's a sobering experience to listen to average law-abiding citizens presenting evidence of conduct by an official law enforcement agency of the federal government that borders on the criminal." More hearings and descriptions of abuse followed. Also in 1979, NRA-ILA drafted reform legislation introduced in the House by Representative Harold Volkmer, Democrat from Missouri, now retired and a member of the NRA Executive Committee, and in the Senate by Senator James McClure, a Republican from Idaho. While the legislation would be modified over the next 7 years of struggle, it required proof of criminal intent for gun charges, cut back greatly on the power to forfeit guns or hold them without filing charges, and defined engaging in the business of dealing in a way that would exclude collectors' traditional sales and swaps. Then came 1981. Ronald Reagan entered the White House, Republicans took the Senate, and Senator Strom Thurmond, Republican from South Carolina, replaced Ted Kennedy as the chairman of the Senate Judiciary Committee. Reform became possible, but it was still a battle. For over a year, unofficial negotiations were conducted to work out issues. Add words to clarify here, replace an entire section there, add a new idea that further protected gun owners. The new version of the legislation also added features that barred forfeitures if the firearm owner was acquitted in the criminal case, allowed FFLs to have and sell non-inventory guns with minimal record keeping, and eased restrictions on interstate sale of long guns. In the 97th Congress, which was 81 and 82, the Senate Judiciary Committee reported out the bill, but with a killer amendment providing a 14-day waiting period for pistol purchases. In the 98th Congress, NRA tried again, and in 1984, a bill reported out without the waiting period, but the Senate leadership refused to bring it up for a vote. Senator McClure countered by attaching the measure to a vital appropriations bill. As a price for getting it removed, the Senate leadership had to agree to expedite the bill when Congress convened, to hold it at the chair so that it did not need to start over in the Judiciary Committee. In the 99th Congress, 1985 and 1986, Senator McClure got an early vote on the bill, and it passed the Senate in July of 1985. It had taken 6 years of hard labor to bring it this far. Now would be the hard part. The Speaker of the House in its top dog was Representative Thomas Tip O'Neill of Massachusetts, a key ally of Ted Kennedy and thoroughly anti-gun. Upon hearing that the Firearms Owners Protection Act had passed the Senate, Judiciary Chairman Pete Rodino pronounced it dead on arrival in the House. That boast turned out to be a tactical mistake. Representative Volkmer knew that under the House rules there was only one way around a committee chairman who bottled up a bill, a discharge petition. A successful petition would discharge the committee from considering the bill and bring it up for a vote. This to succeed under the rules, a discharge petition had to be signed by a majority of the entire House, 218 members. The names of those who had already signed were known to the House leadership, which could therefore pressure and intimidate them, but kept secret from anybody else. The procedure was so difficult that only 7 petitions had succeeded in the past quarter century. One of the standard responses to someone seeking signatures on a discard petition was, "I agree with your bill, but I want to give the committee system a chance to work." But Representative Volkmer was happy to point out Rodino's boastful dead on arrival remark, and this made an impossible excuse. Still, gathering signatures was hard work. In 3 months, Representative Volkmer and the NRA had garnered 158 signatures. Then another month of work pushed that number to 203, plus 10 promises to sign, nearly enough. Rodino realized too late that the discharge position was going to pass, and he quickly reported out a rival bill that had a few Firearms Owners Protection Act provisions, mostly watered down, and included many anti-gun provisions. Firearms Owners Protection Act provisions had undergone many changes over the past 7 years, mostly in the way of additional protections and guarantees. The core feature of Representative Volkmer's 1986 bill were intent required to convict. The Gun Control Act was a strict liability statute. Even an honest, accidental violation was a felony. Firearms Owners Protection Act dramatically changed this. It required for most offenses proof of willful violation, meaning the person had to know not only what he was doing, but that it was illegal. Engaged in the business, this had been widely used to entrap collectors. 4 to 6 sales were all it took for a collector to be guilty of engaging in the business of dealing with guns without a license. Firearms Owners Protection Act changed this by specifically defining engaging in the business as dealing in firearms as a regular course of trade or business with the principal objective of livelihood and profit, which could not include a person who makes occasional sales, exchanges, or purchases of firearms for the enhancement of a personal collection or for a hobby, or who sells all or part of his personal collection of firearms. Confiscation of firearms. Under the Gun Control Act, firearms could be confiscated on the claim that they were intended to be used in a violation. The Firearms Owners Protection Act dramatically changed that rule. Seizure would in most cases require proof of a willful violation. Intent must be proven by clear and convincing evidence. The firearms to be seized must be individually identified and intended for misuse, and legal proceedings must commence within 120 days of their seizure. Finally, if the collector or dealer won the case, the government would have to pay the owner's attorney's fees. The bill's opponents protested correctly that gun owners would have protection that no one else had in the forfeiture proceedings. Confiscations and driver's revocations, despite acquittal, without the Firearms Owners Protection Act, prosecuting agencies had forfeited collections and revoked licenses, despite the owner being found not guilty in criminal proceedings. Firearms Owners Protection Act provided that the seized guns must be returned upon their owner's winning acquittal or dismissal of charges, and that the license revocations could not be based on such charges either. Prohibited possessor reforms. Under the Gun Control Act, conviction for a felon in possession of a firearm could be obtained even if the possessor had received a pardon, had the conviction set aside, or had his civil rights restored. Under the Firearms Owners Protection Act, winning any of these remedies would restore gun rights, unless the order explicitly provided to the contrary. Dealers' records. The Gun Control Act allowed unlimited, repetitive search of dealers' records and inventory, which had been used as a tool for harassment. The Firearms Owners Protection Act allowed only one annual inspection plus inquiries to trace specific guns or to carry out a criminal investigation of someone other than the dealer. If the records are taken, the dealer must be given a copy so he can continue his business. Gun shows. The Gun Control Act only allowed licenses to transfer guns at their licensed premises. The Firearms Owners Protection Act allowed dealers to conduct business at events sponsored by groups devoted to the collection, competitive use, or other sporting use of firearms, making possible gun shows as we know them today. Transportation of firearms. Under the Firearms Owners Protection Act, notwithstanding any state or local law, a person is entitled to transport a firearm from any place where he or she may lawfully possess a firearm to any other place where he or she may lawfully possess it, if the firearm is unloaded and locked out of reach, so the safe travel laws. These were just the major changes. Firearms Owners Protection Act also expanded licensees' rights to appeal a revocation, allowed dealers' sales of long arms to non-residents if the sale complied with both states' laws, allowed recovery of attorney's fees in any prosecution that was meant to harass or abuse, limited government powers to require reports from dealers, and forbade creation of certain gun databases. So on April 9th, 1986, the battle began on the House floor. When the dust had settled, Representative Volcker's bill had been passed and Chairman Rodino's defeated. Rodino's amendments that would have diluted the Firearms Owners Protection Act provisions on intent and broadened its definition of who must have a dealer's license were turned back. One anti-gun amendment offered by Representative William Hughes, a Democrat from New Jersey, a provision that limited civilian sale of fully automatic firearms to those already existing in lawful ownership, did pass on a highly questionable voice vote. The Hughes Amendment created a dilemma. Investigations showed there was little chance of rescinding it. This was 1986, not 2011. Many House members were already being attacked as tools of the demonic gun lobby, and already feared they had stuck their necks out too far. To rouse them on behalf of full auto firearms was hopeless. The amendment could not be removed. The choice to accept the bill as a package or to kill it as a package. Representative Volkmer has described the Firearms Owners Protection Act as the measure that saved gun ownership as we know it. There is much to be said for this appraisal. In 2011, we seem to be at the beginning of a new stage in the American gun culture. Firearm sales are at record levels, and many anti-gun politicians fear to touch the issue, and courts are recognizing the constitutional right of gun ownership. We have survived this far. For the last 25 years, gun dealers have been subject to arrest on paperwork errors and their entire inventories confiscated even if they were found not guilty. And gun shows had regularly seen half a dozen honest collectors hauled away in handcuffs. Is it safe to say the picture of gun ownership would have been different? In 1986 was the last best shot at getting these protections. To kill the bill, lose 7 years of development, and alienate the majority of representatives who had rebelled against their leadership by signing the discharge position would have ended the hopes for stopping the many abuses. In 1986, the gun rights movement really came into its own when it established its power to win on the offensive, even with one House of Congress under anti-gun leadership and the mass media in fervent support. When the fight began with David Moorhead's testimony 6 years earlier, NRA-ILA and the other pro-gun groups were in their infancy. When President Reagan signed the bill into law in May 19, 1986, they had earned their spurs. So that offered a lot of information to me as I read it the other day while we were live, and I felt it was worth taking the time to read that one just in its entirety. So looking forward to the comments. It's written by Dave Hardy back in 2011 about the 1986 Firearms Owners Protection Act. Thank you for supporting our project. If you'd like to buy us a cup of coffee, check out our Patreon channel.
The guys and gals at gunwebsites.com encourage you to take a CCW class every year, practice at least once a month, and carry every day. Thank you for watching gunwebsites.com.